Well, good afternoon, and thank you for coming on such short notice. I'm Dave Kopel, the Research Director of the Independence Institute, also an adjunct constitutional law professor at Denver University Sturm College of Law, and I've been counsel for the sheriffs ever since this case began. With us today is Sheriff Justin Smith of Larimer County, Sheriff Mike McIntosh of Adams, and Captain Mitchell, also of Adams County. I'm going to make some brief remarks and then turn things over to Sheriff Smith, and then we'll all be around to answer questions. 2 years ago, the sheriffs started the appeal in this case after a decision from the trial court that ruled against us on all the issues. We're very pleased today that the 10th Circuit Court of Appeals has entirely vacated the trial court's decision against us on the merits of this issue. The 10th Circuit decided on procedural grounds that, in essence, the first case never even happened. It's been wiped off the record books, it has no effect, and the 10th Circuit has provided us with the procedural roadmap for how to bring a second case, which we certainly will. And now let me turn it over to Sheriff Smith.
Well, I would just like to add on to David's comments. Certainly from the beginning for the sheriffs of Colorado, it's never been about us as sheriffs or about the organization. It's been about defending the constitutional rights of the citizens of Colorado. This case moved rather quickly for us in the beginning and truly went into uncharted territory where we knew from the beginning our biggest challenge would be establishing standing in a case like this. Very difficult. So as we went in, that was our biggest challenge. While not every step along the way, certainly given the results that we had originally hoped for, it did give us a bit of a roadmap as to how to get our case back up and through. We believe, based on the limited information and the conversations with our counsel, that we have a better idea now from the courts how they see a case like this needs to be framed to get into federal court. And again, the standing there really comes back to the ability to establish how somebody can show the harm with the laws that were enacted by the state 2 years ago or 3 years ago. So we feel like we have a roadmap to that and a better chance to do that. As well, this brings back up the realities that the citizens of this state were told in 2013 when these laws went through. They were going to make the state safer, they were going to reduce firearms crime. We haven't seen that be the case. And so, as difficult as it is to have some of these decisions, the reality is it's given us the opportunities to see some of the results of these laws and where they've gone, how they've impacted citizens of the state, how many of the promises that came with them have proven to be false promises. So we won't pretend that everything in here is what we were looking for, but it does give us the chance to bring that Heller case, better defined for standing, back up to the court. So from here, it is to get back with our attorneys, and it's times like these, I'll be honest, it's good to have a constitutional attorney to help guide you through these because they're difficult. They're not as simple as a 1 or 2 line piece that comes out from a ruling. It's a matter of looking at them. So that's where we're at today. Sheriff McIntosh.
The only piece that I would add that Justin has commented on is when we get back to our communities and we talk about the safety and the protection of our communities, really the last line of defense for our communities are the sheriffs. And this is just another case in point of the sheriffs standing for the rights of their citizens within their communities. And we are pleased today that we get to have the opportunity to go back into the courtroom and make sure that we are continually defending the rights of our citizens, whether it's the Second Amendment or the First Amendment. It is the sheriffs that in Colorado that want to stand and do stand as that last line of defense. Thank you.
Thank you. We'd be happy to take any
I
questions.
don't know who's best to answer this. For the layperson, what does this mean? Is it back to first step and now you have a whole new chance to win, I guess? Or if you could just explain a little bit more for the common person, that'd be great.
That's exactly right. The 10th Circuit explained procedurally how they believe the new case should be brought. The there is now no court decision anywhere in the 10th Circuit that is against our point of view. There's no valid, still existing court decision which upholds one word of these 2013 anti-gun laws. So we have the roadmap to bring the case in the structure that the 10th Circuit wants it brought, where we can bring forward the merits, including the fact that this background check law has actually reduced background checks, including the fact that this magazine ban has, in the words of the Attorney General defending it, the intent and purpose and effect of reducing people's ability to fire shots in home self-defense.
So you say
Well, let me
roadmap.
follow up on that.
So in the last 2 years, you've been able to do research that will help you prepare better for the next case.
Everybody knows more about the case now than when we started in May 2013, and we think that experience plus the 10th Circuit's roadmap will help us move the next case forward expeditiously, hopefully.
What do you mean by roadmap? What are they telling you to do?
The Article 3 of the Constitution says that federal courts can only hear cases and controversies. And as they've developed that, that means parties have to have standing, which means some concrete harm they're suffering as a result of the law. And we actually did bring forth a lot of concrete harms, but the court said, well, the 10th Circuit, when it's a criminal law you're challenging, those kind of concrete harms you explained aren't enough. You have to show different other types of concrete harms, and that's what we'll do in the next case.
Are you guys arguing that the current laws, the gun legislation that passed in 2013 is unconstitutional?
It violates the Second Amendment to the United States Constitution, and it also violates the Americans with Disabilities Act. That's absolutely been our case all along. And the district court didn't agree with us, but that disagreement has now been wiped from the books.
If I can, when you talk about being able to show the harm, can you talk about how you do that? Do you bring forth somebody who's been harmed? Is the lawsuit change? How does that happen?
Yeah, and that, of course, we're some of the plaintiffs in the case. There were many other plaintiffs with their own attorneys in the case. Outdoor Buddies, which represents people with disabilities who participate in the outdoor sports. The Colorado State Shooting Association, other individuals, firearms stores. And so all of the attorneys will be getting together and talking about exactly how to do that in compliance with the 10th Circuit's roadmap.
But is there like a general idea of what kind of person you would need to put forth to say they were harmed?
That will be a matter of an intense discussion with the lawyers, and we will make sure to come in with a belt and suspenders, and probably several pairs of belts and suspenders. We will do it multiple ways.
This is very difficult for folk to understand because, agreed, there's nothing to say, we have a ruling vacating the lower court. On the opposite side, there's no court ruling saying these laws are unconstitutional. In addition, the 10th Circuit dismissed everybody as a plaintiff. I mean, everyone said they had no standing. So how, we had dozens and dozens of plaintiffs in addition to the sheriffs. Who do
Well,
we make a plaintiff?
they were dismissed as plaintiffs on the claims that they brought in terms of
Right.
how they said this law harms us. That decision allows all of the plaintiffs to come back with a differently structured case.
Understood.
In terms of how the
Trying to-
harms
trying to
are
understand-
demonstrated.
Trying to understand what
Yeah.
that differently structured case would be.
Well, that's a intricate matter of law that the plaintiffs' attorneys will be working on in the coming weeks.
Very good. But for the part of the county sheriffs, you do intend to go back into a court to challenge these two laws. Is that correct?
Yes.
Were there any other questions?
Well, back to
Remarks?
this point, so won't some argue that this has vacated the case entirely and you don't have another case?
That's not how a motion to dismiss works. And that's what ultimately the 10th Circuit said, is just dismiss this case because the parties didn't have standing. The procedural result of something like that is the same parties can come back with different evidence about their standing.
So what's the different evidence that you're going to come back with that you didn't argue in this case?
That will be discussed in great detail by the lawyers, and we have plenty of ideas, but, well,
Can you share some of those?
no, I'm going to save those for the for when we file the new complaint, because that's obviously a preliminary thought at this stage. I mean, the ruling just came out late this morning, and I've read it once, but all the lawyers need to study it extensively and do more research on the cases cited by the 10th Circuit, and make sure that the new case is fully in alignment with what they want.
Well, so just generally, though, what kind of harms are we talking about here? So obviously, we've seen the specific harms that you've pleaded before. What are we talking about generally here for the new harms that can now be shown?
One of the things the 10th Circuit said is when you have a criminal law, what is the risk that the plaintiff actually faces a credible threat of criminal prosecution? So we'll be certainly working to follow their standards on that.
Have there been criminal prosecutions under any of these laws?
Well, this is sort of the catch-22, as the sheriffs have been saying all along, including when they tried to meet with the governor who wouldn't meet with them back in March of 2013. These laws are completely unenforceable, and in fact, they haven't been enforced because they can't be.
Dave, for us gun owners, explain to gun owners why this is a good ruling for us today. And this is a good ruling, is it not?
It is a very good ruling. It's, the optimal ruling would be the Supreme Court would have ruled our favor 9-0 by this point. But where we were in the case after that loss in the district court on the merits, that's been erased. So if you can think of it in football terms, your team lost 21-0 in the game, and then the 10th Circuit comes in and says, you know what, actually that game never even happened. Wipe it off the record books, and if you want to start a new game with some different rules, go for it. But I also, one other thing to add is we've also had some really important successes in this case already. The case was filed in May of 2013, and in June we filed a preliminary injunction motion, and the result of that preliminary injunction motion was we essentially got rid of two of the worst provisions of the magazine ban. The law that said a grandfathered owner had to keep continuous possession of the magazine, which had been interpreted to mean you couldn't, say, leave a magazine with a gunsmith for repair. And now you can loan your magazines to a friend for 10 years if you want to, because of our success so far. And likewise, there was a provision that not only banned magazines of 16 or more rounds, it also banned smaller magazines which could be converted to hold more. And really, any magazine can be converted to any size. That's just the technicalities of how magazines work. And so as a result, companies like Smith & Wesson were cutting off all of their shipments of semi-automatic pistols into Colorado. Not just the models that come with magazines of 16 or 17 rounds, but cutting off the shipments of guns that come with a standard magazine of 7 or 9 or 12 rounds because of this designed to be readily converted ban. And because of our suit and our preliminary injunction motion, we essentially got rid of that as well. So gun companies were able to resume shipping to Colorado semi-automatic pistols that have standard magazines of 15 or less. And it's only because of the sheriff's lawsuit that we were able to get rid of that incredibly damaging provision, which had the effect of outlawing all of the magazines used by semi-automatic handguns.
I have a question for any of the sheriffs. Back to Dave's point a moment ago. How have you been enforcing these laws, or have you at all? And how has that looked in your county?
Well, I can tell you the reality of it. One of our concerns was the way this was established. It could be held over anybody's head, but the practical realities are they're truly unenforceable. When the citizens were promised this was going to achieve certain things, I can tell you in our county we had a case brought by a municipality because of the way this is structured. The threat and a charge was made against an individual. However, they dropped it because they discovered it was unenforceable. The citizens were told by those that pushed this it was going to create miracles. Violence would evaporate in their communities, essentially. This was going to be the cure-all. We've seen that's not the case. However, I can tell you, sheriffs, we understand that when the law is held up as a hammer, even when that hammer is not used, that hammer can be used as a threat against individuals exercising their constitutional rights. So that's the reality is the fear is still there with a good number of law-abiding citizens, but for those who truly are criminals, that hammer has not been used on them. That hammer's not been used in this state, to my knowledge, on a dangerous criminal. And this has revealed that. We wouldn't have had that when we first went to trial. And without going into details, because some of these things, again, are strategy discussions, I'm aware of other cases in this state where, because of the background check, law-abiding citizens were deprived of their firearm that was in police custody, that there was never a dispute, that they were the legal owner and they had a right to have it. And I know of at least one individual that was deprived for months. That was one of our concerns. But when our case went to trial, that hadn't occurred yet. So it gives a chance to go back through these with our attorneys and look at what's going on, because the threat of prosecution can have a significant consequence against individuals, even if that's not used, just knowing it can be. So I think this gives us a chance to look at those kind of cases. Sure, you have more? Okay.
The 10th Circuit ruling said that it can't be a speculative threat of criminal prosecution. It has to be a credible one. So how do you establish that if it hasn't even been used against lawbreakers?
It does not have to be an actual prosecution that's been filed. And as you say, the rule has been around about a credible threat of prosecution, and exactly what does that mean. And that's been a gray area in the law, and sort of necessarily will always to some degree remain a gray area in the law. But we will structure the case as best we can to comply with the standard they articulated.
Please stand by for a moment, please. I know Jerry has to leave, he's on deadline.
Okay.
We've got one question back here.
Yeah, I'm just gonna mess with the mics real quick.
Sure.
Apologize.
No problem. Thank you.
This is for the sheriffs.
Yeah.
If you can hold on a second before you take that question. All right, you know the radio deadlines.
Absolutely. It's easier than carrying reel to reel
Are you
around.
done? I know, right? Okay.
So this is for the sheriffs. When you learn of a gun store that is selling these high-capacity magazines that exceed the 15 rounds, what are your actions?
I'm not aware of any stores in my jurisdiction that have violated the law, so that's where I'm at right now. And I'm not aware of anywhere in the state, even the governor's own law enforcement officials that have ever filed charges. So there's one of the realities. Again, how some of this was written left it open to interpretation on some of these cases as to what was in violation there.
So if a store is selling magazines in excess of 15 rounds, they are in violation of the laws. I mean, about as clear as it could be. And I have heard of stores that are doing this. So now what I'm hearing from you is that we just need to call the local sheriff and let them know so that they will.
I can't comment on your speculation as to what things you said you've heard. If you ask me what I know, I do not know of any cases that have been brought forward.
Right.
If those cases are there and you're being told these are prosecutable cases, then I would say where are those prosecutions?
So
if you don't have a case where that's occurred. So I'm not going to go into speculation of what somebody heard about a gun store. I can tell you in my jurisdiction we've had no such cases.
Good. That's good.
Thank you.
And that's achieving what the bill intended. And what I just want to make sure is that to ensure that the law is carried forth, that we continue to have the gun stores being responsible. That was the main point of the law, is to get them out of the gun stores. And so we need to make sure that the law enforcement is when they are aware of these being sold, that they do shut it down. And so now from what I'm hearing from you, we just need to notify the local sheriff.
Well, I would ask you to take that back to the police agencies who, on behalf of their mayors, stood up and swore with the president and the governor this was going to be a great thing and it was going to do miracles. They haven't filed any cases, so I guess you might want to go ask them before you come ask the sheriffs. Thank you.